offers the parties control over how proceedings will be conducted. Since the parties are not in physical presence of each other, it takes the emotion out of the dispute and encourages a cogent settlement. Further, it encourages better enforcement of the solution recommended or imposed by the chosen institution. In online dispute resolution, instantaneous circulation of information reduces the time. Further, circulation of information on internet makes the defaulting party apprehensive of bad publicity in the electronic market. Once the arbitrator, conciliator or mediator is acquainted with the facts and issues, he passes the award. The parties merely have to interact with the adjudicators through internet to the site of the chosen organization and present one's case and data messages for the cost of a local phone call. The problem areas which I have already discussed with you are matters involving complex questions of law or mixed questions of fact and law may at times be difficult to be resolved through online dispute resolution. Further, electronic non-performance is not always easy to establish. When a software publisher or database owner does not supply the necessary access code, presumption of non-performance can be taken against him. However, no such presumption can be taken when it becomes difficult to decide whether the fault lies in software or the operating system. Mediation, conciliation or arbitration, whatever is the mode of resolution opted by the parties for online dispute resolution, places obligations on the parties which are sanctioned by law. Electronic mediation and conciliation present lesser problems as only a decision acceptable to both the parties is passed, but electronic arbitration is contentious because of the various demands imposed by national laws and international agreements, as it needs to be established whether electronic arbitration satisfies the conditions of the law or of international agreements. Thank you.
Thank you, Dr. Meera. We dealt with the most advanced aspect of alternative dispute resolution. It is not common, or we are yet to start that model. Evolving stage, we can say. We already started, but most of them in few cases. But always dreaming is better than the reality. That's why this novel. Dr. Meera discussed about if it is more laws, more legislation, more litigation, more cases. We are everybody is saying we are the biggest democracy, biggest, largest judiciary. We are surviving because of that democracy and judiciary. Because there is no collapse since independence, because of this vibrancy in our democracy as well as the judicial intervention. We have a mandate to legislate some laws. Whenever we are going through the constitution, you can see state has to. According to the needs, we have to legislate. Of course, I think Madam talked about the judicial impact is not properly taken care of. That may be the reason, but we can't say this. We have more legislation. I am dreaming about litigation-free world. Is it possible? No. Because this litigation we are not thinking as an enmity. This is a vibrancy in our democracy. Two persons have a dispute. First they will talk each other. If it's not like that, they will go for litigation, argument, for settling an issue, not for fight. It's something different. That through ADR mechanism we are reminding them to take care of. But I am more worried about the formal judicial system. Because ADR system is of course for the settling quickly, speedily, less expensive, and don't take much time for settling that issue. But in my mind, this our formal judicial system is causing an enormous delay. today. His name is Nishant Singh. He will deal with that aspect also. Before he start the presentation, I want to remind him, our system, judicial system or court system is more on litigation oriented. Unlike America or other things, pre-litigation process we are not giving any importance. That's why whenever a client is approaching the lawyer, immediately taken Vangalatnama Irish. That is a system. No, if you are doing this in the pre-litigation stage in a chamber through a conciliation or after interviewing or discussing that we are giving proper advice, they are reluctant to pay also. Maybe that may be the other reason. That is one. The litigation-oriented judicial system or administration delivery of justice delivery system is one of the reasons for causing the delay. Second aspect is the benchmark relations. The lawyer is having many matters in the same day. He wants an adjournment. The more appearance will get more benefit. The judges are also listing 70 cases, 100 cases per day. Please think about it. One judge can hear how many cases a day? Is it 5 or less than 5? In my experience, I never practiced in a court. But my experience telling me a judge can maximum hear 5 cases in the trial court. If it is in the high court, 2.
In trial court. Right? If a murder case or
no, I am not saying about the serious crime.
One case take time. It can work.
Yes. So this is a system. But no, we are if you have seen the list, you can find
High court it is 60, 70.
60, 70. Maximum a high court judge can hear 2.
Undated. The cases have to just in 3 months.
Yes.
Looking at the number of cases, we have to case. Therefore, they have to case.
That's why here my insight is whether we need effective court management, case management. If so, how it is possible? If you are not doing, or our judicial system is not delivering justice timely, we will approach alternative forms. For example, now the banks are not conversant or not ready to approach any formal court of law for their settling or recovering something. They are having private agencies. Maybe that's why Gundas are now very less. You can join the private agency and act as a private enforcement agency to recover this one. You think about it, you are not delaying this matter to next 10 years. If you are crossing 2010, the parallel system will streamline and they will establish.
But Supreme Court declared
It
this
should
illegal.
be yes. No, I'm saying you have to see. That's why we lawyers, judges and general public and have to think loudly. What is the alternative? How we can strengthen the system? I think government came to know and they started the dialogue, saying how we can. Their judicial reform agenda, first agenda is delay of how to tackle the delay of cases. They are forming some grids in state level, national level to tackle this issue. Then in one of the aspects, law minister himself stated, the government is the biggest litigant in our country, either the state government or the central government. If they are deciding they want to settle their own with their own system, you can reduce the delay and reduce the pendency.
Would not be sure whether a particular medicine is banned or not. Whether a doctor was administered you a particular medicine which is easily available on the shelf. I'll give an example, Nemolit, Nimesulide. It's banned, but in India it's available option. Without even a prescription, one can go and buy. So, this awareness must be there. At least the patient himself or herself is able to know what exactly the doctor is administering to him or her. The treatment, say a case of angina, or say a case of peptic ulcer, or a case of appendicitis. How the doctors should proceed. It's very simple. All of us today have a mobile phone. Each one of us is surfing the net. Only difference would be between a planned and an unplanned surgery or a treatment. Unplanned would be emergent situations. Even then, most of us would be having a phone where one can visit a website. A doctor says that you have to be treated for a bypass or for a angioplasty. One can easily come to know what are the parameters suggested by Medical Council of India or any medical association, which one should be adopted. The awareness. The point which I am trying to convey is the awareness. If the patient is equally aware, even the same awareness would be available with the specialists, with the doctors. I'll take you to a situation where a doctor in Delhi, in any corporate hospital, who is having the best of resources, and is doctor with same institute, let's say passed from AIMS, MD Kadambi from AIMS, but is practicing in Silchar. After 10 years, if I ask a question to myself whether they both have the same kind of knowledge, answer would be no. But if today we are unable to use technology or the internet or these associations, they are unable to perform their jobs, then who is the victim? The society. But the point that I am urging today is that the course of our treatments, the latest innovations, all these situations, all these things should be available on the websites of these bodies. These bodies, like in National Board of Examinations, which conducts D&D examinations, which is equivalent to MD and MS, they have got 54 specialties between MD and MS. Now, in these 54 specialties, it will not be easy even for me to give the names of all 54, or even for a doctor to give all 54. But they exist on the website of any of these professional bodies in the course of treatment, or even the new thing, which is a medical simulator. Even if that is made available, or even a refresher course, a medical simulator, working on it is made available by the state associations, the IMA, the state medical associations. The surgeons can go, they can refresh themselves whenever they want. It's not mandatory, it's voluntary. One can go and he can work on simulator for 2 days or 3 days. You can learn the latest things. After passing a MD from AIMS 10 years back, how do you feel that a person who is situated in a remote corner of India would be having the same knowledge, which today is possessed by a person who is passing today? According to me, the person may have gained a lot of experience, but on technology front he would have been a sheer loser. So therefore, the geographical differences, I think, should be mashed up, should be taken up on the technology, and we must see and we must request that these associations and these statutory bodies, they must take up the awareness campaign, which would surely reduce the cases of medical negligence. Thank you.
Thank you, Mr. Gussain, to touch the topic comparing the plight of a doctor with that of an advocate, and also throwing light on the complexities faced by the doctor when treating a patient. Next, I will request Dr. Richa Ranjan, who is principal with Law College, Panchayat.